All day, our paralegal was receiving messages from the buyer's lender saying everything was on track and they expected to close on time. Later that afternoon, the lender found something in the buyer's disclosure and was not able to close. The seller had all their worldly possessions on a truck leaving Florida for their new home. The buyer had everything on a truck waiting to be unloaded at the new home. And somebody started raising their voice, and the next thing someone said was, "We're going to sue." Today we're going to talk about Florida real estate contracts. And by the end of this video, we'll give you at least a few key points on what you should look for when you're considering buying Florida real estate. So Sid, one of the questions we get all the time is, do I need a Florida lawyer? What do we tell clients when they ask us about whether or not they need a Florida lawyer?
Right. So with a real estate transaction, the short answer is no, you don't need a Florida attorney to represent you in a sale or a purchase of a home. But you should carefully consider engaging one because there are a lot of different parties that are involved in the sale and purchase process. There are lenders, the real estate agents, possibly appraisers, inspectors. So it really would benefit a person to engage an attorney at least at a minimum to review the contract.
So one of the things that comes up sometimes when we're talking to clients about Florida residential real estate is clients will ask us about the so-called standard contract. And sometimes we'll get a call and the client will say, my realtor says it's just a standard contract. You don't need the attorney to look over. Why don't you tell us a little bit about what exactly they mean when they call a standard contract and what's the difference between the standard, so-called standard FAR contract and a Florida as-is contract?
Right. So any attorney will tell you that there's really no such thing as a standard contract. But what Brian is referring to is there are two different types of contracts used in residential real estate in Florida. So you have the as-is FAR contract and the standard or traditional contract.
Let me just throw one thing in. So for FAR, what we're talking about, because we're using abbreviations,
right.
It's the Florida Association of Realtors and the Florida Bar got together and they said, you know, these are really important sort of standards that should be in most contracts. Mm-hmm. So that's the starting point on those forms.
Right,
yeah,
right.
Okay.
Of course, those forms can be altered, changed by your attorney.
Exactly. Or anybody with a computer.
Exactly.
Yeah.
So the as-is contract essentially says that the buyer entering into the purchase gets a free look at the property during the inspection period, and they can back out of the sale for any reason, whether they don't like the paint color on the house or perhaps there's a more significant reason for them backing out, like an issue with the roof. So they're able to back out and receive back their deposit for any reason. Now, the standard FAR contract says that you should get the inspection, but you can't back out for any reason like you can with the as-is contract. It provides that the seller of the property is required to contribute a certain percent or dollar amount in order to fix any issues that the buyer points out, up to a certain amount. There's always a cap on it. So,
right. So that's provided in the contract.
It is. Yeah.
Somewhere in the contract it'll say something like the buyer, the seller is able to resolve any issues up to, let's say, like 4% or something like that in repairs. And then after that, they could both negotiate or do whatever they wanted to do.
Exactly.
But to your point, on the as-is contract, if somebody wanted to get out, even if, like, and we've had this, you know, where a client will go down the road and they're, you know, going in good faith and they want to buy this house, they have an as-is contract, and then the realtor calls them at the last minute and says, that other house that you really wanted is now back on the market. Mm-hmm. They could pull out for any reason,
That's
as
right.
long as they're within that period of you know, the window of the inspection period.
That's right. And just to add to that point, with the as-is contract, the buyer is agreeing to take the property as is at the time of entering into the contract. However, that still means that the buyer and seller can negotiate during the inspection period in order to get a credit or the buyer can request certain repairs to the property. And if the seller doesn't agree, the buyer can back out during the inspection period.
That's a great point. And you and I, we use those frequently, I'd say, and I think generally in Florida, as-is contracts are used more frequently, right?
I think that it's the most popular type of contract in Florida.
Right.
Yes.
And one of the things that we're going to talk about a number of things today on Florida real estate contracts that should be helpful for our viewers. But one of the things we talk about is when we're representing the seller, and a lot of times because we're probate and estate attorneys, we are also doing, probate administration. Whenever we have a seller who is selling a property in a probate administration, we really encourage them to sell it as is, because we don't want our clients as sellers to get involved with contractors who may or may not do the appropriate work on a project, and then later our seller could be called back in because of some warranty issue or whatever. Right.
So it really does limit your liability to give a credit versus agreeing to make a repair to the property.
Yeah, much cleaner, right?
Much cleaner.
Much cleaner. And then the other thing that we want to point out, and Sid and I always tell our clients this: if you're the seller or if you're the buyer, when you're doing an as-is contract, make sure that you have as much time on that inspection period as you can get.
Right.
Because a lot of buyers don't realize, someone, it may be a realtor, it may be a friend, say, 5 days is okay, or 7 days. Look, once you get under contract, you better have an inspector ready to go, because inspectors are busy too, and the good ones that you want, might not be available to go out tomorrow.
Right.
So you got to have a lead time in there.
And to that point, you'll get a general inspector in there as soon as you sign the contract and as soon as you can get one scheduled. And that general inspector might say, well, you need to get a specialized inspector here to look at, termites or, whatever it is.
Absolutely, great point, because the general inspectors know a little bit about everything.
That's right.
But then they might identify a problem like with ductwork or something like that in the air conditioning, and they might say, look, from our inspection, all we can tell you is we're not getting the ratings that we want on our air conditioning, and we think it's something in the ductwork, but you need to get an AC guy out here. Now you got another couple days.
Right.
So if you have like 15 days to do an inspection and you already have your inspector lined up, you're really in a much stronger position. And you need a couple days to think about it. And one last point, the inspectors don't just give you an inspection. A lot of them don't give you an inspection as soon as they're done. They go back to the office, take a day or two and say, I'll get it to you in a day or two. So there's another, you need to have some lead time. So that's a really important point.
Right. So the point here is try to get the longest inspection period you can. You can rely on. So Brian, can you tell us a little bit about a disastrous situation that we've run into with our closings involving a homeowners or condo association?
Sure. I mean, one of the things that we see is something that our friends and our clients from up north are not as used to as the people that live in Florida, is we have a lot of condo associations and we have a lot of homeowners associations. And the first key there is the client needs to understand that when they're buying a property that's in one of these associations, they're buying it subject to certain restrictions on the deed. And every buyer and every seller is agreeing to those restrictions. The other key point we usually bring up early with the clients in our conversations in this area is that those restrictions can be changed by the board as well.
Right.
And they have to understand that if a majority of members of the community decide that they no longer want to allow certain things within the community, they can make a change to those association rules. So it's a really good point for buyers from up north to take a look at the association rules, understand that they really need to take them seriously, and that they may be enforced against them. And so if there's any kind of an issue that they have with respect to a rule within the association, they need to resolve that before they actually commit to buying the property.
Right. And another thing that any buyer should factor into the cost of the home is the assessments and the monthly or quarterly dues that'll be paid. So,
exactly.
The difference between assessments and quarterly dues, the dues are something that you pay, like I said, on either a monthly, quarterly, annual basis, and that's just for the general upkeep of the property. Then you have assessments, which are for bigger ticket items like, for example, replacing a roof on a condo or renovating a clubhouse. So it's important that when you also look at the governing documents of the association, that you also look at the financial health, and that'll be provided with the entire condo or association documents.
Exactly. One time, you probably remember, I mean, we've seen it several times, but fairly recently, recently we were dealing with a client that had the intention of going in and purchasing a condo unit, and the client's plan was that for the first couple seasons they'd rent it out for the season,
Right.
and then after a couple seasons they were going to be in a position to move down full time. But in the meantime, off season, they wanted to use the condo.
Right.
In the middle of the contract discussions, when they first came to us with a fully signed contract, we weren't part of the prior discussions before the contract was submitted. We noticed in the rules that there was a restriction on rental, and rentals had to be for no less than one full 12-month period, and they couldn't rent until they had owned the property for at least 12 months, and they had to get prior approval of the association before they entered into a rental agreement
Right.
with a tenant. So that created a real problem for the client.
Right. And tell everyone exactly what it is that we did in that situation.
Well, on condo associations, you have a 3-day right of rescission of the contract. In other words, 3 days after the seller provides you with a full copy of the condominium documents.
Right.
One of the things that our clients have been able to utilize in this area, sort of leverage, is that sometimes people are in a rush with regard to providing the documents, and if they don't provide a full copy of the documents, they haven't satisfied the statute, meaning that you still have the 3 days in order to rescind the contract.
Right.
Or if they don't provide you with full financial disclosure for the condo association, they haven't complied with the statute requiring them to provide all this information on the condo association. So in that one case we were talking about, we simply used a 3-day right of rescission, and there was nothing else wrong with the condo. There was nothing else like in the way of repairs that the client could use in order to break the contract. But because of the 3-day right of rescission, they were able to get out and find a more suitable property.
Right. And to that point as well, it's kind of like the inspection period under an as-is contract. You don't actually have to give any sort of reason as to why you're backing out during that 3-day period. It doesn't have to relate to what you found in the condo or association documents.
Yeah.
So tell us a little bit more about some other restrictions, like restrictions on weights of pets. Sometimes they don't allow pets at all.
Right.
Associations. So
yeah, that's one that catches a lot of clients off guard. They don't even think about the fact that the association may have a certain rule about pets, and they've got some beloved little Frankie from somewhere that that they want to bring from New Jersey or whatever, and it's a problem for the client. It's a serious issue. So again, one of the things that we always do when you and I are working with the clients, especially all of them, but anybody from a northern jurisdiction, is to tell them, take a close look at those rules and regulations, and don't just accept the fact if someone tells you, don't worry about it, lots of people do it, because it could become a problem even if it's sort of ignored at a certain point in time,
for example,
and it could later be enforced.
New board member in there that doesn't like dogs, or
exactly.
And starts to actually enforce the rule that's already in the association documents.
Yeah, and we want Frankie to have a home. So there was another case that we had recently that I'd like you to share with our viewers, which had to do with a tree where the pool was supposed to be. What was that about?
Right. So we had a client come to us, and this was after he had signed the contract and after the inspection period had expired. And he was.
We love those situations.
Yes, it happens. It happens frequently, but there wasn't a whole lot that we could do about it. So this was after the inspection period had expired, and there wasn't a whole lot that we could do about this. The client had just gotten a survey back, which showed that there was a large tree in the center of the property. And of course, the client knew that when he went into the sale, when he walked around the property, but the sales agent told him that no problem, we're going to be able to remove the tree and you can put your dream pool in the backyard. Well, that wasn't the case. We ended up figuring out that this was a protected species, and so it was really unfortunate for the client, and it put a lot of undue stress on him, which could have been avoided if he would have hired counsel previously. But we were able to at least work with the city to move rather than remove the tree to another part of his property. So It worked out well in that case for him. It's just something that you should be aware of if you're purchasing a property.
Yeah, that was a great point. I thought of something as you were mentioning that. One other thing that's sort of I think, a growing issue, to make a pun, about Florida properties and associations is that species that are not native to Florida, in a number of cases around South Florida especially, some of the municipalities are enforcing the required removal of non-native species.
Right.
And I know in my homeowners association, that's something that our association went through, and that added up to quite a bit of money, which later became a special assessment for all the members of the community. So you really have to sort of get your hands around the fact that these associations, they have certain rules. And, you know, if you're going to buy in that area, you're going to be subject to them. So you just need to make sure you do your homework and you feel comfortable with, you know, what the rules are and what's going on with the history of the association and, you know, how the board is with the members and, you know, the other homeowners and all that. So great points. Yeah. So I hope you've enjoyed the video this morning, and we've talked about a lot of the issues with Florida real estate and contracts and homeowner association. On our upcoming video, we're going to talk about homestead, and we've got sort of a little bonus in there that we're going to talk about how to, you know, get a homestead property through a probate process without waiting months and months for delay. Right. Which sometimes can be an important issue for our clients. Remember, one of the keys to take away from this is to talk to a experienced Florida real estate lawyer before you sign your contract so that you can avoid a lot of the big mistakes, some of which we, you know, explained today. We hope you enjoyed the video. If you did, please give us a thumbs up. That helps other people find the video on YouTube. And subscribe so you don't miss any of our future episodes. And follow us on Facebook, LinkedIn, Instagram, and Twitter. Like our page, The Duffy Law Firm, on Facebook, and you'll get notices on all our upcoming videos. So stay tuned, and we hope you'll watch our video on Florida Homestead. Homeowners Association. So okay, all right. Was there a bug? No. She was like, okay. Okay, sorry. I'm so sorry. Are we going to use that? I figured that would get sick. Yeah, we're definitely going to use that.